I'm going to give you an overview on the process for running a motorcycle accident claim. One thing to bear in mind if you are involved in a road traffic accident involving a motorcycle is that the law for a motorcycle accident and the principles of the claim are no different to any claim involving a car driver or even a pedestrian. The main difference is that in motorcycle accidents, quite often, the victim of the accident is more seriously injured. It is therefore important from the outset to really address those issues, because the future effects of any serious injuries can be long-term, and therefore your solicitor in due course will need to be able to explore the potential for various heads of claim that may arise and for which you will need to be compensated at some stage in the future. If you have suffered quite a serious injury, you are likely to be taken to hospital from the scene of the accident. There will be a detailed record of the injuries that were presenting at the time of your arrival at the hospital. Quite often, however, other injuries will come to light at a later stage. It is therefore important that you do not just go to hospital, but you also consult with your GP and make sure that any other symptoms that have then presented are recorded on your records. One issue which will arise at an early stage in any road traffic accident is with regard to the vehicle. Quite often, a motorcycle damaged in an accident will not be able to be driven from the scene, and therefore the police or other organisation will actually arrange for that vehicle to be recovered and taken into storage. If you have the benefit of fully comprehensive insurance, when you notify your insurers of the accident, they will take charge of the motorcycle damage claim and will deal with any storage and recovery charges that are arising. If, however, as quite a lot of motorcycles are, you only have third-party insurance, you will need to instruct a solicitor at an early stage, because they will then be able to instruct an engineer, and they will be able to arrange for your vehicle to be removed from storage at an early stage in the claim. The reason this is important is because you have to mitigate loss. If you allow charges to incur to an unreasonable level, insurers may at a later stage of the claim object to paying them, and you may be presented with a personal liability for any fees that have not been recovered. It is always good at the outset of a claim to gather as much evidence as possible so as to try to establish liability. Obviously, if you are suffering from a serious injury at the scene of the accident, that is not likely to be possible at that stage. But the police who attend that accident will normally obtain details of any witnesses, and in the case of a very serious accident, will probably prepare sketch plans to give an assessment as to who is likely to have been at fault of the accident. Any prosecution of the other party is always helpful in establishing liability, as it becomes a prima facie issue that if they've committed an offence such as driving without due care and attention, it is evidence of negligence, although it doesn't necessarily prove it. Where possible, if you can obtain information regarding witnesses, it will help your solicitor prepare your case at an early stage. Insurers, where possible, will try to establish issues of negligence against you, not only just to deny liability, but perhaps to offload some responsibility for liability onto your shoulders rather than their insured. If you can obtain witness evidence, photographs, and the like, it helps your solicitor in combating any such arguments that may come forward at a later stage. Insurers tend to have an adverse view of a lot of motorcyclists and will be trying to criticise the manner in which you've been riding your motorcycle, the speed of your motorcycle, and generally the circumstances of the accident to try and establish some issue of liability against you. It is therefore in your interest to make sure you've got as much information available as possible so as to remove those arguments before the insurers get underway. Once the claims process is underway, your solicitor will need to obtain medical reports detailing the extent of the injuries that you have sustained. These are not difficult to obtain. There are medical experts who specialise in providing reports, what we call medico-legal reports, specifically for the claims process and for the courts. Your solicitor will be able to have access to a bank of experts and will instruct the most suitable expert for your particular injuries. They may be physical injuries, for example, any fractures or soft tissue physical injuries, which can be obtained through orthopaedic reports, A&E consultants' reports and the like. Quite often, however, where you've had quite a disturbing injury, there can also be a psychological injury, and a psychiatric report may have to be obtained to establish the full extent of the emotional effects that the accident has had upon you. There can also be more specialist injuries, such as head injuries and the like, where more specialised doctors have to be instructed. That is in the hands of your solicitor, and your solicitor will guide you as to the nature and the extent of the reports that are going to be required. During the claims process, your solicitor will also need to gather information regarding any financial losses that need to be recovered. Those obviously can detail things like your vehicle damage, storage and recovery charges, but also will include things like loss of earnings, medical expenses, treatment expenses, and in the case of very serious injuries, we'll be looking at the potential for you suffering any future loss of earnings or having a risk in the open labour market in the future if your injuries might restrict you from certain types of work. Your solicitor should be discussing with you at an early stage what those potential heads of claim are going to be, so that whilst the medical reports are being obtained, the evidence in relation to those losses can be gathered, thereby putting you in a position to start discussions for settlement once your medical evidence is complete. Once you've got all the medical evidence and your financial loss documentation together, your solicitor will prepare a schedule of loss detailing the full extent of the financial loss claim. The evidence and the schedule with its supporting documents will be sent to the insurance company, and hopefully, subject to them having agreed liability, they will then enter into the negotiation process to try and settle your claim. Your solicitor, and possibly a barrister instructed by your solicitor, may then get involved in discussions with you over the potential value, so that the process can take place whereby offers and counter offers are made with a view to trying to settle the claim.